Hello. Thank you all for joining us today for a discussion on Donald Trump's disqualification from the Colorado Republican primary ballot. My name is Seth Masket. I'm a professor of political science and director of the Center on American Politics here at the University of Denver. We're here to discuss several pending actions by the U.S. Supreme Court, particularly in the case of Trump v. Anderson, which will likely have an enormous effect on the 2024 presidential election and on U.S. politics in general. For this discussion, we're joined by two experts who are professors of law here at the University of Denver's Sturm College of Law. They are particularly qualified to discuss how the ballot disqualification impacts both the freedom of speech guaranteed by the First Amendment, as well as the specific disqualification provisions of the 14th Amendment. First, we have with us Alan Chen. Professor Chen is a leading national expert in free speech doctrine and theory, the law of federal courts, and public interest law. He's the co-author of, among other things, the book Free Speech Beyond Words, The Surprising Reach of the First Amendment. He's also published numerous scholarly articles with top law reviews, including those of Columbia University, the University of Michigan, and Vanderbilt. Outside of teaching, Professor Chen carries an active litigation docket on a range of issues, including political protest and lethal injection. Our other panelist is Professor Ian Farrell, who researches and teaches on criminal law and procedure, constitutional law, and the philosophy of law. His work has appeared in numerous top law reviews, including those of William and Mary, the University of Texas, and Villanova, among others. He's previously clerked at the Massachusetts Court of Appeals, and he has taught at the University of Texas and the University of Wollongong in Australia. Both Professors Chen and Farrell have submitted amicus briefs on this particular Supreme Court case of Trump v. Anderson, with Chen writing about Trump's claims that his words on and leading up to January 6 are protected by the First Amendment, and Farrell writing regarding Trump's comparison of January 6 to the George Floyd protests of 2020. I would also like to give a brief shout out to the students of my American politics or my American presidential nominations class, which normally meets at this time, and who are joining us in the audience today. But first, I'd like to give just a very brief timeline that led us to where we are today. So last September, a group of Republican and independent voters filed a lawsuit against Colorado's Secretary of State to remove Trump from the ballot based on a violation of the 14th Amendment, Section 3. This section prohibits people who have taken an oath to support the Constitution but also participated in an insurrection or rebellion from holding public office. That lawsuit was actually led by Norma Anderson, the former Colorado Republican Senate Majority Leader. Last November, a Colorado judge rejected this lawsuit, saying that Trump did participate in an insurrection, but that the 14th Amendment Section 3 does not clearly apply to the presidency. However, in December, Colorado's Supreme Court overruled that ruling, finding that the section of the 14th Amendment did apply to the presidency and that Trump could not appear on the Republican primary ballot in Colorado as a result. Trump appealed this to the U.S. Supreme Court. Shortly thereafter, Maine's Secretary of State issued a similar ruling, striking Trump from Maine's Republican primary. As of now, Colorado's Republican and unaffiliated voters have a Republican presidential primary ballot in their homes with Donald Trump's name on them, but we're waiting to learn whether any votes for Donald Trump will actually count. As of this morning, and we checked this pretty closely, the court has not issued any opinion, even though Coloradans have their ballot and have just about a week and a half to put those ballots in the mail. Now, running alongside this is another case that we're also waiting for the court to rule on, which concerns whether Trump or any other president is immune from prosecution for their actions during their presidency. We'll get into that one in a little bit. So what's going to happen is I'm going to ask our panelists a few questions. If you have questions for the panel, please feel free to type them in using the Q&A feature at the bottom of your Zoom screen. We will do our best to get to them before our hour is up. But I'd like to start with a question for Ian Farrell. So the Supreme Court held oral arguments in this case, in the Trump v. Anderson case just a few weeks ago. I'm curious, what issues did you see the justices being most fixated on during this?
Yeah, first of all, thanks for inviting me to be on the panel. This is an issue that's both fascinating and of profound importance. So it's a nice combination there to discuss. So you're right. The oral arguments in this case were very interesting and perhaps more clearly than usual, really focused primarily on sort of one set of issues. And those set of issues were related to whether a state has the authority under Section 3 of the 14th Amendment to remove a presidential candidate from the ballot. So the conservative justices in particular really hammered Anderson's counsel with arguments that this would allow essentially a single state to decide the entire election for the entire country. I wasn't surprised by that. I was a little surprised that one of the liberals, Justice Kagan, also made that argument, it seemed, quite forcefully. Among the other liberals, Justice Sotomayor was relatively quiet, but Justice Jackson, who's the newest member of the court, surprised me a little. She pushed very hard on a different argument, namely that Section 3 does not apply to the president at all. The only other line of questioning I thought would be worth mentioning to start out is about whether or not, or is related to whether or not the states have the authority here. And that was some questions and comments made by Chief Justice John Roberts, who basically said, look, if Colorado is allowed to take Trump off the ballot, that will spark retaliation, and all over the country we'll see red states taking Biden off the ballots. And the council responded to that by saying, well, no, there's no plausible argument for Biden having been engaged in insurrection. And Chief Justice Roberts said, yeah, to you maybe, right? Suggesting that there was either a plausible argument that Biden somehow had engaged in insurrection, or that there's no way for courts to differentiate between them. And that to me was quite shocking. That sort of, equalizing or whataboutism by a Chief Justice of the Supreme Court.
Yeah, thank you. I thought those were all really interesting, particularly the question about whether a state can strike a candidate from the ballot, but if not them, who, right? Since we don't actually have a single person, we don't have one presidential election. We have 50 presidential elections, or 51. Alan, Chen, a question for you. Were there particular questions from the justices that surprised you during oral arguments?
Sure. It was a fascinating argument, and so going to there are a couple things that I think might be important to the case. There's a question that relates to the issue of whether states, as opposed to the federal government, can act here under Section 3 of the 14th Amendment, and that is whether Section 3 is self-executing. That is whether we need nothing else besides the text of the 14th Amendment, subsection 3, to decide whether President Trump should be disqualified from the ballot. And there's some evidence that, well, there's very little precedent here, but there's a case where Salmon P. Chase, the Chief Justice of the Supreme Court, sitting as a lower court judge, writing to the circuit back, which the court justices did back then, has a decision in a case called In re Griffin, where Justice Chase argued that Section 3 is not self-executing, and that Congress must set up a procedure to carry out disqualifications under Section 3 in order for it to be put into effect. The Congress in 1870 did just that and passed something called the Enforcement Act that allowed set up for a process for disqualification. But for unknown reasons, this came up with the oral argument that that act was repealed. And so there's nothing currently in place. This relates very closely to the question of whether the federal government or the state governments can remove an officer from the ballot, because if it requires congressional authorization, or at least a congressionally sanctioned procedure, then without regard to what the federalism issue, then the state can't remove Trump from the ballot. This case was brought under state law, under a procedure allowing to sue for enforcement of the Constitution. That's not something, obviously, that Congress set up. I was also a little bit surprised, as Ian was, about the extent of the focus on the policy-based argument about what's going to happen if we uphold this Colorado Supreme Court. Are we going to have just basically partisan warfare in every state about who's eligible for the ballot. And you can imagine in a highly polarized environment that like we're in right now, we could see, some outlier states basically, making up some decision about disqualifying Biden for this reason or for other reasons. And that we could have that could have an effect on the national election. Imagine if it happens in a swing state, for example, a state that could actually turn the electoral college one way or the other. So I take those. I was a little surprised about how the extent of those arguments, but I understand why the court's taking them seriously.
Thanks. Since we just got a question in on something you had just mentioned, so I thought I'd throw that in now. You had mentioned that enforcement mechanism for the 14th Amendment that was, I guess, enacted for a while and then later repealed. And I'm curious, was this something that was actually utilized? Was this something that actually functioned before its repeal?
Ian, do you want to take that one, or do you want me to talk a little bit about it?
You can go for it.
Okay. I believe it was used. It was a procedure, a mechanism set up by Congress called the Enforcement Act of 1870. That was basically the procedural mechanism by which officers could be disqualified under Section 3. A lot of cases ended up being mooted out because members of the Confederates leaders, many of them were pardoned and therefore found to not have participated, not to be disqualified under Section 3. So I don't actually know the number of how many people were actually disqualified. But we definitely do not have that procedure here. The other piece of evidence that we have about Congress's role here is a part of Section 3 that is in the text, which is that Congress can actually, by a 2/3 vote, overrule a decision to disqualify an officer from holding federal office. And that came up in the oral argument in an interesting way. I believe it was Justice Kagan who said, so a majority of Congress can set up a procedure to disqualify somebody, but it takes 2/3 of Congress to sort of reverse that decision. And so I thought that was something I hadn't thought of before and how the process might work.
Yeah, can I just jump in there on that particular issue? That suggests that at the very least, it's not the role of Congress to make the decision in the first place, but rather the courts. And I mean, the question would then arise if, for instance, the court here decides that the state of Colorado and other states don't have authority to enforce Section 3. They could decide that, and in doing so, say we are making no decision on the merits in terms of whether Section 3 applies to the president, in terms of whether there was in fact insurrection. That would leave the question open for future arguments. The question would then be, is there any federal mechanism in place, even if it's not self-executing? How would you go about getting someone disqualified? And that's something I don't know the answer to.
Ian, one of the things that struck me about the oral arguments in the court was how little the question of whether January 6th was an insurrection actually came up. Colorado's Supreme Court seemed to, I guess, pretty easily decide that it was an insurrection and that Trump was a participant or an organizer. And then there was a ruling by Maine Secretary of State saying the same thing. Do you see this as something, potentially an area of dispute for the court's justices?
Yeah, this is an interesting one. I think that there are a number of different potential explanations for the court not focusing on or even barely addressing that. One is that it was a factual decision by a state court. And so unless there's, quote, clear error, the federal Supreme Court sort of can't overrule that. And in fact, that was one of the reasons the court gave for why it would be problematic for different states to decide this issue for their own ballots, because the courts suggested, what if one state holds a hearing and they allow in certain evidence and don't allow in other evidence, and they conclude that it was an insurrection, but another state maybe on different evidence because they have different rules for the hearing, decides otherwise, it could well be that neither of those are clear error. And so even though the US Supreme Court gets to decide the legal issues related to Section 3, they may have their hands tied in terms of not being able to resolve that dispute. So that's one reason for them steering away from that. Another reason may be that if they decide on other grounds, that allows them to simply avoid the issue of weighing in on whether there was insurrection. And I wouldn't be surprised if the court desired to keep out of as many of these issues as possible.
Thanks. Alan, I would like to actually touch a bit on the nature of your amicus brief. Can you describe what your argument was about Trump's First Amendment rights, as this seems to be relevant to not just this case, but a number of current cases against Donald Trump related to January 6th? That is, even the president enjoys the right to free speech. Are Trump's, his false statements, his false tweets about election fraud, or calling people together in a rally and then marching them to the Capitol, are these protected as free speech?
Right. I'm happy to address that. So President Trump argued in his briefs, his lawyers argued that everything that he is, every piece of evidence about his supposed insurrection or leading the insurrection was protected under the First Amendment as political expression. And I joined a group of other First Amendment scholars on an amicus brief that argued that to the extent that the factual findings of the state trial court are correct, and that many of the things that President Trump did were directly leading to an insurrection or involved in an insurrection, that under a current Supreme Court law, the concept of participating in an insurrection is synonymous with incitement to illegal conduct, which is not protected by the First Amendment. There's a Supreme Court decision called Brandenburg versus Ohio that imposes that was addressed specifically this issue, the borderline between political advocacy and incitement to riot or incitement to violence or other illegal behavior. And in that case, the Supreme Court said that in order to convict somebody who is engaged in that type of expression, the state has to show that the person intended to cause an immediate breach of the peace or incitement, and that it was very likely that that would happen. And our brief argues that under the facts of this case, all three of those elements were met by or could be met and were met by the factual record as the trial court concluded, so that he has no First Amendment defense if he participated in insurrection. He also engaged in incitement, and therefore his speech was not protected.
Thanks for that. I want to also bring in another question from the audience here. There's a question that I'll just read it, during oral arguments, Justice Clarence Thomas pointed out that after the Civil War, no state barred a candidate from the ballot for 14th Amendment Section 3 reasons. Thomas presents this as evidence that Colorado's activities are unprecedented. Couldn't the same historical finding be evidence that the 14th Amendment had worked well as a deterrent? How should the court be interpreting this?
Yeah, I think the alternative suggestion is at least a plausible one, right? As Alan mentioned earlier, there were a lot of people pardoned, so that has an effect on the application of Section 3 in the immediate aftermath of the Civil War. But this we have to keep in mind, and it's sometimes hard to sort of put ourselves back in that moment. But if you think about where you were and when you learned about what was happening on January 6th, it was a shocking development. It was something that was new to certainly modern American politics. And so it was a genuinely unprecedented moment. And so a plausible explanation for why the insurrection clause hasn't been invoked regularly or hardly at all over the past 150 years is because there haven't been insurrections.
Yeah, unprecedented is the word that cuts through every piece of this case, right? So The disqualification's unprecedented, but so is the president's involvement in the insurrection. So, but if I could just briefly add on to the Ian's answer, which is one thing that did come up at the argument is when disqualification operates. And so you could argue that the Colorado Supreme Court's decision to remove Trump from the ballot is premature, that it would only be if he were to be elected in November that the disqualification clause would kick in. That is, it can be used to bar somebody from holding office, but not bar somebody from running for office, which are two distinct things. And I think that's something that the court seemed to be interested in. And it kind of is part and parcel with this argument that Congress could make the decision before the inauguration to invoke the disqualifications clause, but that is not something that can be done at the ballot stage.
Yeah, can I just jump in there? That's a really important and interesting issue. And I've got to say, I found the arguments for that position to be fairly underwhelming. So from a policy perspective, think about what that would mean, right? That someone who will inevitably ultimately be unable to run for president is able to be on the ballot. And so people will waste their votes and so forth. But the arguments went along these sorts of lines. They said, well, he's not currently disqualified. The reason he's not currently disqualified is that Congress could basically overturn the disqualification by a 2/3 vote. Because they can do that later on, the argument was by the lawyer, he's therefore not currently disqualified. Just as a matter of semantics and logic, that just doesn't convince me. That's like saying, well, if you have a job for which you're not allowed to apply if you're a felon, if you're a convicted felon, well, anyone could apply because in the future, the governor could pardon you. And so it just doesn't, that's like saying someone's not married because in the future they might get divorced. So the reasoning behind that I found to be somewhat tenuous.
I think I'm with you on that one. So I'd like to briefly pivot to this other case. So there's another case currently pending before the court, and we're awaiting a ruling on that as well. Special Counsel Jack Smith is prosecuting Donald Trump for trying to subvert the 2020 presidential election. Trump has claimed in this case that he has absolute immunity from prosecution for his actions as president, and that this immunity extends to him even as a former president. A court of appeals has already rejected this argument unanimously, but it is now before the Supreme Court. Obviously, if the court rules that presidents are simply immune from prosecution for anything they did as president, that throws out a lot of these cases. I'm curious, I would like to hear from either of you. Are we likely to see anything along these lines? What is your impression of where this is going?
We're trying to figure out who's going to go first. I'll take a stab at it. So the status of this case is, as you said, the federal DC Circuit Court of Appeals has decided unanimously that President Trump is not entitled to immunity, and the President Trump has asked the U.S. Supreme Court to hear that case. And Jack Smith, the special prosecutor, I think has sort of filed his response. I think there's some noise, some speculation that the court might not take that up. I can't imagine they won't, because it's such a momentous issue, and leaving the Court of Appeals decision in place would still leave some uncertainty about the immunity question that could be raised later if Trump were to be convicted. So I think they're going to have to address it. I think in many ways this may be more important than the ballot disqualification case, because the polling data that I've seen suggests that the one thing that might affect support for President Trump is his conviction for any of the criminal activities he's been charged with, even among some of his supporters. So to the extent that we get a decision that he's not immune from the U.S. Supreme Court and the prosecution goes forward, I think that might have a significant influence on the actual outcome of the election. Now, what will happen is, of course, he will appeal that conviction, and he will continue to claim that he was, this is a witch hunt. But I don't think the appellate process won't be completed by November, even if the trial is. And so I think that's going to be a criminal conviction hanging over a current presidential candidate from one of the major parties. I think it I think have a significant impact on independent voters and even some Republicans. So I think it's important. I hope that the court will take it up, and I hate to read tea leaves, but the DC Circuit decision is so compelling and so well done that I would be surprised if the current Supreme Court found that he was immune for this, to the extent he was involved in the insurrection.
Yeah, I second everything that Alan just said, including the last part, that it would be an astonishing legal decision to overturn the Court of Appeals in this case. Like if the Supreme Court decides that former presidents have absolute immunity for criminal conduct while they're in office, then like the law is so clearly on the other side of that if they rule that there's absolute immunity, I mean, we might as well just pack up and go home. Like, what are we doing? Like, if one of my students was given this question on an exam and read all the precedents and said, yes, there's absolute immunity, they wouldn't get a good grade.
Yeah, I mean, by this logic, if they held that, then Biden can simply, kidnap Trump and lock him in a dungeon or something, and that would be perfectly, he'd be immune from any prosecution for that or something like that.
Yeah, the example that was given in oral arguments, I believe, before the Court of Appeal was, could a president order SEAL Team 6 to take out a domestic political opponent? And attorney for Trump said, yes, that would fall under the immunity.
Okay, so that's a strain. Okay, got it.
Yeah, I would be shocked if they went that way.
I wanted to return to the argument at least one of you brought up before about the 14th Amendment case, and this was the idea that the 14th Amendment Section 3 doesn't actually apply to the presidency. And if you actually read the text of it, it mentions a surprising number of offices there. It mentions Congress, state legislature, electors, and a number of things. It does not specifically mention the president. So I'm curious, and this was, of course, the basis for an earlier court ruling in Colorado. I'm curious, could this be the thing the Supreme Court's decision hinges on? Did you see the justices interested in this question? I don't know either of you on this. Sorry, Ian, didn't mean to interrupt you.
Okay, I'll go first. Yeah, thank you. So I don't expect this to be the basis for the Supreme Court's decision because it seemed that the majority of the justices were more interested in the state authority issue. But certainly Justice Ketanji Brown Jackson, for instance, raised this a number of times. So I wouldn't be surprised, for example, if there was, say, a Justice Jackson concurrence on this point, or if it was one of the additional rationales provided by the court. Just to flesh out the argument a little bit more, the advocates for Trump point to a number of reasons why they don't believe that Section 3 applies to presidents. One is that the president is not expressly included in the list, although there is a catch-all phrase of all other officers under the United States. Another is that it talks about referring to officers who have previously sworn an oath of office to an oath to protect the Constitution, to uphold the Constitution, whereas the president swears an oath to protect the Constitution. Another argument they made, these are all fairly hypertextual arguments. Another argument that they made was that while the president is an officer well, maybe it's the other way around. There's a difference between being an officer and holding an office, and in other sections of the Constitution, there is a reference to officers which, in the context, clearly can't include the president, and therefore it should be interpreted here to not include the president. Just to sort of give a sense of the policy sort of ramifications of this, that would mean if the president is excluded, first of all, it's only former President Trump out of all of the people who have held office in recent memory who would be excluded, because every other president has either been a governor or a senator or held some other position that is controlled by Section 3. But also, putting that aside, if we think about why Section 3 was included in the 14th Amendment, it was to prevent former rebels in the Civil War from regaining control of the US government. And so if this argument is correct, that means that someone who used to have a lowly position could once again have a lowly position in the new government. But for example, the president of the Confederacy, Jefferson Davis, could become president. And that is close to absurd. And when Trump's attorney was asked that question in oral arguments, he was asked what possible explanation or rationale could there be. His attorney admitted, "I can think of no rationale."
Yeah, I think I agree that I mean it is a hyper technical textual argument that that only Justice Gorsuch seemed to be really interested in pursuing at the oral argument, which is not surprising given he's hypertextual in his approach to decision making. But I agree. I mean, it seems like an absurd result that a insurrectionist, the only office an insurrectionist is not barred from, is the president of the presidency of the United States. And it just seems to fly in the face of the underlying rationale, as Ian said.
Yeah, and this is why I was so surprised with Justice Jackson's line of questioning, because she followed it up not just with a textualist argument, but she said, "Isn't there evidence that the government, the drafters of Section 3 were primarily concerned with infiltration from the lower levels of government up?" And I thought the oralist had a good response to that, citing numerous examples of where people had referred to higher officers. And then with regard to the argument about whether officers of the United States or officers under the United States includes the president, the oralist pointed out that on the floor, when they were discussing, when the Senate was discussing this language, one of the senators asked, "Why isn't the president included in this list?" And the response given was, "Oh, well, he's included under the other officers." And so given that, on the one hand, there's no express mention of the president, there's also no express exclusion of the president. And so in those contexts, we look to other clues as to what the likely meaning is, including the legislative history or the history of the drafting of the language in this case, whether the result would be absurd and so forth.
Okay, thanks for that. I have a few more questions. And again, I want to encourage anyone in the audience, if you have other questions on your mind, please feel free to type them in. I would like to ask a question that I guess more conceptually and I guess a little more politically here for either of you. The court often declines to make decisions that would specifically affect the outcome of an election. And I think for fairly good reason, although they've obviously done so in the past in a few high-profile cases, such as, say, Bush v. Gore in 2000. It seems like no matter what the court does in this case, their action will be highly consequential. Do you think there's a desire by many justices just to find some way to leave Trump on the ballot to avoid looking like they're interfering, regardless of what they think the law and the Constitution actually say to do in this situation?
I absolutely think that they are trying to find a way to not to reach a unanimous decision that Trump is not disqualified under Section 3, even if it's a hyper technical one or one that has to do with the self-execution. And I do think, Bush versus Gore notwithstanding, I do think this is this is such an unusual circumstance historically, and it's hard to make generalizations from it. But I do think that the court wants to look like it is not political, not, and it. Yeah, but of course, either way, it's going to be viewed that way. If they leave them on the ballot, then they're going to be, people will say they're in the pockets of the Republican Party, and if they uphold the disqualification, which is very unlikely, that they're putting, they're weighing in favor of Biden for the 2024 election. And I think they desperately do not want to be viewed as taking a sides either way. I actually thought another out that they didn't reach. Of course, I also thought this was going to happen Bush versus Gore, and that was not true. Was that they would decide this is a political question, something that not suitable for judicial resolution that must be decided through the political process, and that surprisingly didn't come up at all. So, like, I don't think it was even in the briefs or in the if it got mentioned in the oral argument, it wasn't a major emphasis.
Yeah, I had exactly the same thoughts about the political question doctrine. It was raised in the brief of the Colorado Republican Party, but not in the Trump brief. And there was some mention at some point or some question about whether or not that meant that the point had been conceded by Trump, since it wasn't in his brief. I'm not sure whether that's true or not. But yeah, I was shocked that it wasn't discussed. I completely agree with everything Alan said about them. Two things. One, they want it to be unanimous or as close to unanimous as possible, because every additional liberal justice who sides with keeping Trump on the ballot gives an additional buffer to the charge of this being purely political. And then secondly, I think that's also one of the reasons why they might find appealing the idea of saying, this isn't for the states to decide. Because by doing that, they can say, we didn't even make a decision on whether Trump is qualified or disqualified, whether it was an insurrection, not an insurrection. It's just not the job of the states. And then later on, they might also say, it's not our job either, it's up to Congress.
So we have a question from an audience member here who wants to know, and so do I, when can we expect a SCOTUS decision on this? But I think, and asking the important question that, Coloradans have their ballots. Some people have likely already submitted their ballots. What happens to those votes if a decision comes out after ballots are submitted? My impression is that, votes for Trump currently don't count. If the Supreme Court rules they count, they count. But I'm curious your impression on this.
As you know, we originally planned this panel for last week because we thought the court was going to issue the decision last Monday, or at least last Wednesday, and then so we postponed the panel for a week. I think we all expected a decision by now. I don't know what the holdup is. I don't know if somebody is writing a separate opinion, which might which is typically the reason for something to be slowed down. I would expect that, as I said, a unanimous decision written by the Chief Justice on a relatively narrow ground, as Ian said, which shouldn't take that long. And I don't know why. I don't really have a good answer to the question, what happens to those votes? I mean, you could make an argument, Trump could make an argument that people might have not voted for him already because of the concern about the court case, and that might affect the, who knows what he'll say. He'll say there should be a do-over or something, even though he'll probably easily win the nomination from Colorado.
Yeah, I think that the harder question. Well, first of all, I like everyone else, I thought that the decision would be handed down by now. Maybe they're trying to persuade one last judge to either join an opinion or write a concurrence or something like that. My sense as well is that I think the longer this takes for a decision to be made, the more likely it is that it will be in Trump's favor. I think that's likely anyway. The really difficult question will be if they wait until 2 weeks from now and then hold that Trump is not eligible to, in other words, they uphold the Colorado decision, then what happens to the votes? And that's really challenging. I think the one argument, I don't know Colorado election law well enough to answer this. I do know that you have to be authorized to be on the Colorado ballot. That's the whole process that instigated this case. I'm not sure what the rules are for write-in candidates, because maybe you could argue, well, even though he's not qualified to be on the ballot, who knows? I just don't know how that would run. It would be an absolute nightmare, which is why I think that that's not going to happen.
Okay. So I'm actually curious about a somewhat related question about I guess, sort of the legitimacy of the court, or the opinions of people about the court. There was a Pew study last summer in which they did a survey finding, I believe that 44% of Americans had a favorable view of the Supreme Court. If you follow public opinion on most aspects of government, that's actually a very high number. People tend to feel much lower about Congress, about the presidency, and so forth. I'm curious what you see as a likely impact of this case on the reputation and legacy of the court. And I'm curious if a unanimous decision by the court on this case would make a difference with that.
Yeah, I think that's absolutely right. I don't think that I don't think any decision the court makes on any rationale is going to help their public standing. I think I imagine all the justices on the court wish they'd never been brought into this mess, but they're stuck with it, and so I think the best they can do is have a unanimous decision, or as close as possible, on as narrow a ground as possible, and keeping Trump on the ballot. Ironically, I actually think that the correct legal decision here is that the Colorado Supreme Court is correct. I think that may be a really bad political outcome. And so this gives rise to really important, deep, fundamental questions about the role of judges, especially a justice on the Supreme Court. Like, to what extent should you just purely follow the law versus take into account the consequences of what you decide?
Yeah, I would say I'm sure that that's something that's on their minds, whether they admit it or not. I'll also say, even though it's at 44%, that's about 10 points lower than it was 3 years ago. And so even though the court is relatively viewed positively by the public compared to other government institutions, it is relative to itself, it is dropped significantly. And that has to do not with their decisions on election cases, but on probably most likely on their decision to overrule Roe versus Wade a year and a half ago. So I do think that they are paying attention to those polls, even though they claim not to, and that they would like to find a way out of this case that will leave them least damaged.
I wanted to ask another question related to some of what you have been talking about, and that it has to do with like timing and I guess pace. One of I guess a frustration I think a lot of people have had has been that, this and a lot of other court cases pending against Donald Trump seem really important and seem really relevant to voters, seem really relevant to the election, and probably should have happened, say, prior to 2024, right? They shouldn't necessarily be going on simultaneously with the primaries and caucuses. It would be nice to have some of these things resolved before voters actually had to make decisions on these things. I'm curious, like, is that a realistic complaint? Should we really not be thinking about how court case calendar lines up with, the political calendar? Or is this, is just prolonging this actually, sort of make the decision for us? I'm curious what you all think about that.
Yeah, I'm sure Alan will have even more to say about this than I do. But one of the things to keep in mind is that in order for a federal court to hear a case, it must be ripe. And so I imagine, had these sorts of arguments been put before the courts earlier, they may have been dismissed as not yet right because we didn't know who was going to be on the ballot and so forth. And so this may be inevitable in terms because of the way that the law currently works, but it is certainly problematic. And even with the DC Court of Appeals decision regarding immunity for past presidents, where they held unanimously that President Trump does not have absolute immunity, it took them longer than a lot of people hoped for them to make that, to get that decision out. And purely in terms of speculation, there was questions about whether or not there was delay by the Republican justice on that court, because sufficient delay for Trump is essentially a win for him on some of these cases, on most of these cases.
Yeah, to some degree, this was not something that could be controlled. There are many election, for example, a lot of voting rights decisions happen during election years, just because of the rightness requirement that Ian was talking about. And nothing as high profile as what's going on right now, but there are always decisions that need to be rushed during an election cycle. And so I think it is what it is. I think we're kind of stuck with that. But I wanted to sort of add another point, which is whatever happens in this case, I think the actual litigation process involving the disqualification claim is an important piece of the political process, because even whatever the court rules, right, this is put this on the radar of the American voters, both this and the criminal prosecution. And I write a little bit about this, that even losing court battles can have an impact on society and on politics, and so I think it's just part of the discourse, and it's keeping in the news, in the voters' minds, all the things that Donald Trump did on January 6th.
I really like that point, Alan, and it reminds me, I think it's connected to some of the arguments by Trump that keeping Trump off the ballot because of the 14th Amendment would be undemocratic. First of all, if there are like constitutional limitations on who can be president, so it's not undemocratic to prevent a 13-year-old from being elected president. But then there's also that point that you just raised, that having this litigation enriches the democratic process in terms of the conversations we're having about crucial issues.
Also, I'd like to add, insurrection is also anti-democratic.
Yes, that too. Yeah.
Yeah, it's all really a matter of degree. Yeah. So a couple of questions from our audience I'd like to get to. One audience member notes, in Section 3 of the 14th Amendment, it reads, it refers to people who shall have engaged in insurrection or rebellion, or given aid or comfort to the enemies of the country. Is given aid or comfort to enemies, is that clause relevant in this case? How is that even considered?
I think that really is referring to enemies during wartime, more so than in a civil war and insurrection. So as I understand it, I don't think it really is pertinent here.
Yeah, and I don't think that it was argued by Anderson in the case below.
Okay. We also had a question about, and I'm assuming this applies to the presidential immunity case. Is there a precedent from the U.S. v. Nixon case from the early 1970s here? As I understand it, that held that basically presidents were not immune by their sort of executive authority. Does that apply in this case, in either of your opinions?
So it doesn't directly apply. The issue here is different. Nixon was about whether or not material had to be handed over by a sitting president. Here we've got criminal cases against a past president. To the extent that it is relevant it's adds a little bit to the weight of argument against absolute immunity, because in that circumstance they said that the president is not immune, and so that's just another, I guess, context in which the court has said presidents aren't immune. That's so there may be some kind of analogy there or parallel, but it isn't directly applicable.
Yeah, the more relevant precedent is probably a case called Nixon versus Fitzgerald, where the Supreme Court held that that a president is absolutely immune from civil liability for actions that were carried out in the course of their official duties. That's the closest thing we have, but criminal prosecutions are very different for the reasons we've already talked about, or the implications of immunity for criminal immunity are huge in terms of just leading to chaos and lawlessness.
Yeah, and the interesting thing about the immunity with regard to civil suit, that's only sitting presidents. And so even if that was considered a precedent, it's only for while the person is sitting rather than afterwards. So yeah, so to the extent that that's analogous, I think that there's a distinction to be made between past and sitting presidents.
Okay. We have another audience question asking, is there a settled legal standard definition of insurrection? Or is it synonymous with the incitement standard from Brandenburg? I would notice I was actually discussing this with my class the other day. I noticed the Maine Secretary of State was using a definition of insurrection as, quote, a public use of violence by a group of people to hinder or prevent the execution of the Constitution, unquote. Though I don't recall specifically where they drew that definition from. And I wondered, is that basically what we're using here? Do we have this defined from other areas of the law or other areas or other relevant court cases?
There is certainly no definitive interpretation of the word insurrection as it is used in Section 3 of the 14th Amendment. And so to the extent that the term is used in other contexts, the question would be whether they or which of those applies here. And so this is something that the Trump team argued. So they were saying that the events on January 6th weren't an insurrection; they were just a protest. And sometimes protests get violence. Violent protests aren't insurrections, and they analogize to things like the protest during Black Lives Matter, which, according to some people, were always full of violence, which isn't true. But even if they, to the extent that there was violence at those, one way to think about insurrection versus other forms of protest, like the way I think about it is protests are an attempt to convince the government to change the way it's acting, its policies, etc. Insurrection is an attempt to change the government, namely take the legitimate government and replace it with a different government. And so I think that's the core difference. And then there's obviously going to be arguments about the details, as well as, which is something that was addressed in the factual hearings by the Colorado court here, did what Trump did support or encourage or participate in the insurrection if there was one?
Yeah, I don't have a lot to add. It would be wonderful to have a definite definition of insurrection that is 100% guaranteed not to come out of this case, unfortunately, because I think it would be helpful for the future.
Thanks for that. I think we have time for just one more audience question that I'm going to take here. Person writes in, on a more positive note, regardless of the court ruling on whether or not Trump can be on the Colorado ballot, what overall benefits come from having a decision like this brought up to the highest court? That is, is it that new conversations about rethinking the presidency and the role or expected behavior are now brought up?
Yeah, and I think Alan's comments earlier really hit the nail on the head in terms of this question, that we are having a conversation about something that may have otherwise somewhat faded in the public's memory. I mean, there are also the all of the criminal trials, but this has placed the January 6th events front and center to an extent that may not have happened were it not for this case.
Yeah,
We're talking about them right now.
Yeah, I agree. And one of the things that was interesting about the Colorado trial court decision, although the judge found that the president was not subject to Section 3, is that she incorporated the findings of the January 6th committee that was constituted by Congress and cited extensively to it. And that's another thing that just bringing that back up to the surface and all the incredible findings that committee made about what happened on January 6th, I think is helpful and should inform our discourse.
Well, thank you so much for that. This has been really helpful. I want to thank, I hope everyone in the audience will join me in thanking Alan Chen and Ian Farrell, particularly for just organizing this, fairly late and for prepping at the last minute on this. Thank you so much. We will wait to see what the court actually rules, but this has given us a lot of insight for how to be thinking about that when it does happen. I want to also thank Megan Grogan and Katie Aker for their support in putting this wonderful program together, and thanks to our audience members for being here today. I hope everyone has a great week.
Thanks, Seth, and thanks, Katie and Megan.
Absolutely, thanks.